Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna PC, immigration.com. Today is June 6th, 2019. This is our bi-weekly community conference call. We'll try to answer your questions the best we can. This does not create an attorney-client relationship. When you enter the call, you are given the limits of the conversation. So keeping that in mind, let's begin. I did not get time today to mark any questions as frequently asked questions. I think we don't have any frequently asked questions, but I'm going to go over it one by one. The first question is from Mira99. Mira wants to know, can we file an LCA 6 months ahead of time? And the answer is yes. So on April 1st, you can file, I think it's 180 days, either 6 months or 180 days, but close enough. So you can apply that much ahead of time. So on April 1st, you can apply for a job that is going to begin on October 1st. That's perfectly legal. Does anybody have a follow-up question on this? Press *5. A follow-up question on this question? *5. Okay, let's go on to the next question. Oh, by the way, folks, there was a posting on DV lottery. We don't do DV lottery cases. Many years ago, we determined that lawyers are not typically needed. So we have not done any DV lottery cases. We don't deal with that area of the law. Roy Rogers wants to know about H1B amendment decision versus EAD-AP combo. You filed a concurrent 485-765-131 215 days ago, have not received your EAD yet. H1B is good till November 25th of the next year. Okay. You filed an H1B amendment 200 days ago, replied to H1B amendment RFE 15 days ago, still have not received a decision. This is one thing you've got to figure out. As I recall, amendments are covered by, not by the 240-day rule, but by AC 21. Have your lawyers double check that. I believe they are covered by AC 21, which will allow you to continue working while the H1B is pending. So there's no 240-day deadline for you. Okay. Have your lawyers double check that. As far as I remember, I looked into this issue a few years ago, and I thought that amendments, transfers for sure, but even amendments are covered by AC 21, not by 240-day rule. 240-day rule is more applicable to extensions without change. Anybody has a follow-up question on this? Press *5. Any follow-up questions on this? Press *5 on your phone. Okay, let's go on to the next question. Arpit Seth wanted to know, is it mandatory for candidate to disclose the perm processing? It's not approved for future employment green card through employer A when applying for H1 through other employer B, and the answer is no. I am not aware of any such requirement under any law that compels you to disclose a pending perm application. I-140s, there may be. I think there is a question on the form I-129. Has anybody ever applied for your permanent residence? Perm is just the first step. I-140, immigrant visa application begins at the I-140 stage. So I don't see any need to disclose it. *5 if you have a follow-up question on this. *5. Okay. Let's go on to the next question. Karthi says, I'm working for company A. My company filed for my green card in EB2. I've got my I-140. After 6 months, I moved on to company B as a manager. Company B sent me to another country for deputation as a manager for 1 year. I came back. I'm working for company A in USA, and my company, this is very confusing. I don't I don't think you've made yourself very clear. I'm not sure whether you want to apply for, obviously, if you have worked as a manager outside USA for a branch of Company B, you can apply for an EB1C for that company if you were employed within the last 3 years as a manager. This is a little bit more complicated, but just to make it simple. So your fact pattern is not very clear. Any company for whom you have worked outside the United States for 1 year as a manager or executive employee out of the last 3 years can apply for an EB1C green card for you. But can a company B, another company for whom you have not so worked, also apply for EB1? No. It is only that company for a branch, sister company, or subsidiary or a parent of which you have worked outside the USA for 1 year. Star 5 if you have a follow-up question. Star 5. Okay. Next question is about affidavit of support. Now, the granularity to which you are asking the question, I don't know the answer. Generally speaking, when you have any shortfall, a good way to do this is to just get a co-sponsor. Somebody who can, and they don't have to be related to you or even a friend. Anybody who's a US citizen or permanent resident can be a co-sponsor. As to using your assets, I don't remember what the exact rule, but that's something you're gonna have to have your lawyers look into, or get yourself a lawyer to look into. I don't know the answer off the top of my head, but you always have the option of going with a co-sponsor. And there's also an option when assets can be converted, from what I remember, when assets can be converted to cash relatively easily, even for your foreign relative, which is your husband in this case, you should be able to use their assets as well. Again, I hesitate to give you a definitive answer because I would have to look at the law. I can't really answer off the top of my head. Star 5 if you have a follow-up question on this. Star 5. Press star 5 on your phone. Okay. Let's go on to the next question. So this is a question about TN applying for a green card through their son who's turning 21 in October 2020. Three questions come out of that. If I submit the application in October 2020, my TN status would not be valid immediately. No, that's not true. TN status is not invalidated just because you filed a green card application, but it makes it highly unlikely that you'll be allowed to travel outside and come back in on a TN if this issue comes up, or that you will be given an extension relatively easily. But just because you file a green card does not automatically invalidate your TN, as far as I know. So in my opinion, off the top of my head, without checking the law, I believe you can continue working even after filing the 485 and waiting for EAD. If for some reason I did not get my EAD before my TN expires, yeah, chances of renewal are difficult. How long to get EAD for IR5 processing? Look at the visa bulletin times, add another year or so to that. Well, wait a minute. You are a permanent, you are immediate relative of a US citizen, so you won't have any waiting time in the visa bulletin. Sorry. So I would say about year and a half for the process, because in the local interview and all, it can take time. Typically, that would be normal. Star 5 if you have a follow-up question. Star 5. Okay. DV lottery, as I indicated, we don't do those cases. Next question is from Vinay Z. I-94, my previous H1B expired May 30th. They filed an extension Feb 2019. So before this expired, got the approval in the same month. My new I-797 has validity date from June 1st. There is a 1 day gap. Will this be an issue? No, I don't think this will be an issue. Star 5 if you have a follow-up question on this. Star 5. Okay. Let's take your call. This one is from, let's see, Kentucky. Kentucky, go ahead, please. You have a question?
Yeah, hey Rajiv, thanks for taking your time
Of course.
to answer my question. So yeah, I just checked with my attorneys, and also they gave me the I-129 and the LCA petition that was submitted to the USCIS, which had the correct dates from May 30th instead of June 1st. So do you think it's better to ask the USCIS to send me an updated I-797 with the correct dates, just in case for the future?
I don't see any harm in it, because that protects you from two angles. One angle is that they might actually eliminate that 1 day gap which they have created. And the second is the fact that you tried to get it corrected protects you just because you made the effort. Okay?
Okay. All right.
So,
Cool.
good luck to you, sir.
Thanks, Rajiv.
Oh, you're welcome. Bye-bye.
Okay.
Indian, they see I have temporary EAD based on I-140 approved and 485 pending more than 180 days. Temporary EAD. I want to work using EAD. What do you mean temporary EAD? There's no such thing. There is no such thing as a temporary EAD. Is there any restriction on the kind of job I can do using this EAD? Sir, first of all, I'm not even sure I understand your question, because there is no such thing as temporary EAD. I'm assuming you're talking about a I-485 based EAD. If you are using it to be employed in a field other than your, not sure who raised their hand. This is Canada. Yeah, Canada, go ahead, please. Hello, Canada, go ahead. We can hear you. We can hear you, ma'am.
Hello.
Yeah, go ahead.
Namaste, Rajiv. My question was from the Indian Desi.
All right, I'm actually
question number 10.
Yeah, I'm actually looking at that right now. So I don't know what you mean by temporary EAD. If it is the employment of
Mine was I-485 based EAD.
So that's not a temporary, that's just an EAD. Are you the primary applicant or are you the derivative?
Yes.
Is it your application or your husband's application which is the main?
This application is my husband's.
Okay. So your husband got the I-140 approved. He filed the 485.
Yeah.
You filed your 485 with him and you've got your EAD, correct?
No, sir. My I-485 filing is pending.
Okay.
Only his has been filed and he has an EAD. And as well as he's on H1B visa.
Okay, hang on.
And
Ma'am, your facts are not at all clear. You said, I have a temporary EAD. I is you or your husband?
Oh, my husband, sir.
So you posted this question for your husband?
Yeah.
Okay, now that makes sense. Now, the answer to your question is, when you have a 485 based EAD, you can do anything you want. Okay? But as a practical matter, it's a bad idea to step away from your job. Why? Because ultimately, the green card that you get from job is based upon a job offer. Whether the job offer comes from the same employer who started the case, or after 180 days it comes from any employer with same or similar position. If you change your careers or you start doing something which is not covered by your professional expertise, government can cast a real doubt on your employment application. So give you an example. What does your husband do, ma'am? Is he in the computer industry?
Yes.
Okay. So let's say he's a software professional. Okay, let's say he's a software professional. Now, once he gets his EAD, what he does is he quits his job and he buys a gas station. Okay. Now, he's not going to get his green card through this job, because the moment the government finds out that he's no longer working in his own field, they will cancel his green card.
Okay.
Okay. Does that answer your question?
Yeah.
All right. Now, he can definitely, because
yeah.
his I-140 is approved and his 485 has been pending more than 180 days, he can take a same or similar job with any employer, but he cannot completely go off track. Okay.
Okay.
Anything else?
Yeah. And so, is AC-21 filing required?
Well, that question has two distinct answers. First of all, what exactly is Supplement J, which is the AC-21 filing you're talking about? Supplement J is simply an offer of employment in a particular form. So let's say that your H1B was sponsored by Microsoft. After 180 days, you joined IBM. But if you know you are going to work in IBM only for 6 months, I don't see any point in filing Supplement J. Then you get a job at Sun Microsystems and you know you're going to be working there for the next several years. You can then file Supplement J. Supplement J should be filed when the job is reasonably long term or when the government asks for it. Sometimes you can get an RFE, government asks for your proof of employment, you have to give Supplement J at that time. Okay?
Okay. So I had one more question.
You're gonna have to make it quick because I've got to finish the calls. So I have limited amount of time. So go ahead, please. Make it last.
Yeah. Last question is about the grace period that comes after the termination of job on H1B. That after if he gets the job, if he quits the job or on H1B, for the next job to be on H1B again, does he have 60 days or 180 days to be in country?
No, he has a 60-day grace period to apply for the next H1B. But that 60-day grace period works like this. We look at the I-94, when is his current status expiring, and 60 days. Whichever is shorter, that's what he gets. So if his I-94 is expiring in 45 days, he does not get 60 days, he gets 45 days.
Okay.
All right. Good luck, ma'am.
Yeah. Thank you so much.
You're welcome. Bye-bye.
Thank you.
Next question is for S. Kiran, currently working in the US on H1B, want to adopt my relative's son and bring him to USA immediately. You cannot. We don't do adoption cases, but I have done quite a few in the past. The way it works is, when you are a non-immigrant, you have to have the physical custody for, I think, 2 years before you can bring the child here. So you have to adopt the child in India, then have physical custody of the child for 2 years, then they qualify for H4. *5 if you have a follow-up question. *5. Okay. Vishal Goyal, EB1A green card self-petition. My wife is a physician. She might qualify for EB1A. Well, you cannot transfer priority dates from wife's case to yours or your case to wife's. It doesn't work like that. Okay. You should file an EB1A. Absolutely. I have no doubt about that. When you have a choice to file multiple cases, especially when you have it under EB1, go ahead and do it. *5 if you have a follow-up question on this. Okay. Next question, Better World Marriage-based green card. Friend had previously married. Okay. So it looks like your friend got divorced and their green card was denied. So it looks like they may have to go through removal proceedings. So typically that means they have to go before an immigration judge. They should be calling, they can't leave the USA. They should be talking to a deportation lawyer immediately. Okay? Because if you leave once your notice to appear has been issued, you are barred from coming back to USA for 5 years automatically. So talk with a deportation lawyer locally. *5 if you have a follow-up question. *5. Okay. Next question is, there's a follow-up question from Anonymous. Yeah, Anonymous, go ahead.
Thank you, sir. This is Network.
Yes, sir. Go ahead.
So, just wanted to know, so in case deportation happens, what are the steps? Is it immediate or what is the process?
You can always take voluntary departure. You can also ask for, you can also do self-deportation. Check with a lawyer, don't do anything yourself. But you don't have to have your friend stay here and suffer. But deportation process can extend for years because first you have to go through the whole process. Times USCIS or actually the courts, immigration courts are pretty backed up. Their times are quite delayed. So it could be years before somebody is deported. Then there's appeal available, appeal to Board of Immigration Appeals. Then there is also lawsuit available. So it can take many years, 2-3 years easily. But if somebody wants to leave earlier, it should be set up with their lawyers, not by themselves. Okay?
Okay, so first, but like they should be getting NTA just in case if it's get triggered.
Mm-hmm. Yeah. Typically, it begins with an NTA.
Okay, and how it can be found, what happened and what court order triggered this?
I have no idea what you just said, but what you should be doing is, this is not my field. Our focus is employment and business-based immigration. So I go to federal courts. I don't go to immigration courts. So you may want to talk with, like I said, a deportation lawyer. They'll be able to guide you in this.
Thank you, sir. Thanks, sir.
Good luck. So this is an interesting question, and this is a common problem these days. What should be my job title? We know that certain job titles government is going to give us a very hard time when we try to get an H1B. Systems analyst, program analyst, programmer. These are all titles, system administrator. These are all titles that government scrutinizes very closely because they ask us to prove how a bachelor's degree in a specific discipline is required for any of these jobs. So the question here from B. Pank says, 12 plus years I've done user-centered design, human-computer interaction, user interface design, user experience design. See, UI UX is very difficult to classify unless you have a degree in human factors engineering, in which case it makes it a little easier. But if you have a degree in computer science or a computer engineering degree, but then you have 12 years of experience, you might be able to get equivalent of something like human factors specialization. So when you have human factors, you might be able to get an approval. But these are tricky cases. You said which SOC code goes well with this degree? That's a lawyer's call, not mine. They have to sit with you, go over your company's job description, go over your company's projects, and then decide. It's not a decision I can make for you. And you cannot really avoid RFEs these days. RFEs are a matter of routine. All you can do is set up your case in a way that increases your chances of success. Okay? In my view, from what I can see, typically human factors engineers do better than computer science or information technology or just plain experience-based cases. Okay? That's the best I can tell you. Star 5 if you have a follow-up question, star 5. All right, let's see. This question is from California. Let's take you in. Go ahead, I can hear you. Go ahead, please.
Thanks, Rajiv, for your explanation. This is Pankaj.
Haji Pankaj.
And just to know one more thing, if I have a expert opinion letter from human factors, it will help me to make my case strong, because generally initially I received RAP and H1 denial as well, saying that the expert opinion which I provided from the PhD holder professors from the universities is not a sufficient proof, or maybe they are not eligible enough to give me an expert opinion letter.
I don't know the answer to that question because I don't know what the professor's qualifications are. You may want to write this down, Pankaj. There are two sources. There are two sources that I want you to include in your evaluation. Okay.
Okay.
One source is for your degree. You must have a college degree, right? What is your degree?
So I have 10 plus 3 education in India. So 10 and 3 साल का diploma. So basically my diploma is in mechanical engineering, but I do have entire total experience is 24 plus.
Okay, hang on. Your degree, your mechanical engineering diploma, is it from a university or a private organization?
In India? No, it's from Mumbai University in India.
Perfect. Because that can be combined with experience. Usually, when you try to get an experience-only evaluation, there are cases that will get you a denial. Even if you have 1 year of college, you'll be okay. So, yes. Now, first thing I would advise you to do is get an evaluation based upon ACRAO Edge. What is ACRAO Edge? ACRAO is AACRAO. AACRAO. American Association of Collegiate Registrars and Admissions Officers. It's an organization whose education databases are consulted and accepted by the USCIS. The database they have maintained is called EDGE, EDGE. So you want a college professor to give you an ACRAO EDGE based evaluation for your education. For the experience, the same professor should be authorized by his college to issue college level credits for experience. Not just any professor. A professor who is authorized to issue college level credits for their college. Their evaluation will be accepted.
Okay, great. Okay.
So do an ACRAO Edge and a college professor authorized to issue college level credits for experience evaluation. All right?
Okay.
Good luck.
Thanks.
Yeah, you're welcome. Yeah, we did a whole bunch of these cases successfully, but there was always a reason why we were able to. Because going in, we knew what we were going to be asked. So we made sure that we had all those points covered. Therefore, most essential thing for you is, first of all, to get the right degree. All right?
Right.
Okay. So, all right, folks, I'm done with the posted questions. We have good 15-20 minutes for any follow-up questions. Anyone has any question, press star 5. Anyone has any question, press star 5 on your phone. Okay, 1, 2. So far I have only 2 people with their hand raised. Anyone has any question? Raise your hand, star 5. 3 questions. Okay, so I'll be answering these 3 questions, calling upon you in the order that you logged into the call. Let's begin with Maryland. So, okay. Maryland, go ahead, please. Maryland.
Hi, good afternoon, sir. Thank you for taking this call.
Of course.
The question I have is about asylum. Do you deal with asylum or you
Oh,
mostly
I
deal
am
with
so sorry.
employment based?
I don't do anything with the asylums. I did one political asylum case in 1993 as a favor to a friend. Never again. Sorry.
Okay. All right. Thank you, sir.
My pleasure. Okay. So now let's go to California again. California, go ahead, please. California.
Hello, Rajiv. My question is about once my 485 with EAD and AP's advanced role is filed, after waiting for 180 days, if I want to pursue a graduate program in some stream, and my employer will be willing to provide any letter of employment offer subsequently, is that a very considerable risk for possible denial of the 485 petition later on?
Yes. There is a considerable risk. I'll tell you, this has a very weird history. Before Trump came to power and things went crazy, under the Obama as well as the Bush administration, we actually had people at the 485 stage going to college, typically MBAs. A lot of technical people went and got Wharton MBA or University of Chicago MBA. They did that, but then they came back to either work for the same employer or in similar job. Okay. So it can be a problem under Trump administration because they are so unpredictable. They try to change policies overnight. It is difficult to say. But if you have a job open with the same employer and both you and the employer are willing to give the job and take the job, you could go to school, and if your green card does not come till your case is completed, till your school is completed, chances are you'll be okay if you take a same or similar job with the same employer or any other employer. So the risk is qualified by the delay, because if you are India born, it's going to take you 10-12 years to get your green card. It's okay if you are in the first 3-4 years to go ahead and do an MBA, get it out of the way, as long as you have a job offer that you can go to from same or similar job. Okay, makes sense?
Okay, yes. The only thing is that what if my degree program is for about 2 years and the green card is available because of priority date being current?
That gets tricky. If I were aggressive about this and I were representing you, I would argue this is none of your concerns what he does in the meantime. If he picks up his bags and goes to India for a couple of years, you can't stop him. As long as he shows up for his job when his green card is approved, Mr. USCIS, this is none of your concerns.
So technically, once my 180 days is complete after the filing of 485, if I went to a graduate program here in the US or in India, or I just went back to India, and my employer is ready to offer me a job subsequent to the coming of the green card, I should be okay.
You should be okay. But this question has been raised by many people, and it's in our frequently asked questions. You can read up on it and listen to other videos that I've done on this. But the basic idea is this. Okay, theoretically this is true. But as a practical matter, can a USCIS officer not raise the issue? Hey, wait a minute. If this job is a permanent job, why did you leave? In your case, it's an easy answer. I left because I wanted to go to graduate school. That doesn't mean I'm leaving the job. Second question is, if this job is permanent, who is doing the job while you're gone? And again, for larger companies, that may not be an issue. But if you have a 3-employee company employer, it'll be difficult for them to make the argument that, oh, this job is simply split between many people.
No. I mean, my employer has at least 100 plus people.
Yeah, so
Uh,
as long as the job continues to exist and you continue to have the intention to join in the future, you should be okay.
okay. Does it make a difference that the employer is a consulting company and I work for their clients?
So far, it hasn't been a problem. They have tried occasionally to raise these issues, but they know they're going to get sued if they try to destroy this industry, the consulting industry. So the answer is it should not.
Okay.
All right.
Okay. Very well. Thank you, sir. Thanks a lot for
You're
the
welcome.
clarification.
Welcome. Good luck. The last call of the day is from New Jersey. New Jersey, go ahead, please.
Hello, Rajiv. This is Vishal. Sorry for joining your call late, actually, today. I had a question posted that I couldn't get to due to some family situation, but I thought I would ask you that question now. I wanted to ask you about EB1A green card self-petition category. My wife is a physician, and she might qualify for that.
I have answered your question.
Oh, sure. Sorry.
Question, you had asked two questions. One was, can she get my priority date? The answer is no. Is there advantage to filing EB1A? Definitely.
Okay. Because there might be risk to the existing EB2 application and when it comes. Yeah.
It's always a good idea to go through multiple categories.
Right. Got it. Okay. And do you handle EB1A applications?
We've done, if not thousands, definitely hundreds of them.
Okay, great. Thank you.
Okay, sure, absolutely. Feel free to send me her resume to help@immigration.com. I'll take a look at it.
Okay, I appreciate that, Rajiv. Thank you.
No problem. Good luck, Vishal.
Thanks.
This was great, guys. We restrict questions to about 13 or 14 now, because that gives me a little bit more time and flexibility to talk to people. We got done in about 40 minutes. That's perfect. So I'll talk to you again in 2 weeks. Take good care. Always a pleasure talking to you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.